Now the important question arises, what will be the practical use of section 6 subclause 2 of Digital Personal Data Protection Act? Basically it says that any part of consent referred in subsection 1 which constitutes an infringement of the provision of this act or rules made thereunder. It also include the infringement of any other law for the time being in force. In that scenario, the consent would be invalid to the extent of infringement. For example, X, an individual buys an insurance policy using the mobile app or website. The data principal gives consent to process the personal data for the purpose of issuing the policy. Apart from that, there is a consent to the clause that the consent data principal inter alia waives the right to file a complaint to Data Protection Board in case of infringement in that scenario. Part number 2 would be illegal because it is going to affect the rights of the consent individual. So whenever the consent is taken and by the virtue of which material rights of the consent data principals are going to be affected in that scenario, with the help of section 6 subclause 2 of Digital Personal Data Protection Act, you may challenge the said condition and could obtain remedy as per law.